Well, it is Sunday morning, and I am in the office getting things ready for another busy week for our law firm in Pennsylvania and New Jersey. And when I came in the office this morning, had a message regarding a person who had a question regarding sentencing in Pennsylvania. And this brings up an important issue that I have to discuss with clients a lot. And with their families, and it's kind of the same advice that I would give someone facing a sentence in a state like New Jersey. So regardless of where you're being sentenced, this piece of advice will help you or a friend perhaps thinking about whether or not he or she should consider a plea deal in a case. And I've always told people the number one rule with regards to pleading guilty is if you didn't do it, you shouldn't plead guilty. And it doesn't matter how good the plea deal is, if you didn't do it, you're going to have to go through a process during a plea that requires you to admit in open court that you did something. And it's not as simple as just signing a piece of paper. I think people often think that's the way it goes. You sign a piece of paper, you get your sentence, and you leave. And it's not that simple. In fact, once a judge hears that you're having concerns or you sound a little apprehensive about doing this, he or she does not have to take the plea. It doesn't have to be accepted. People think that a plea deal is simply between your defense team and the prosecution, and that's simply not the case. Whether you're in Pennsylvania or New Jersey, the judge still has to approve the negotiated plea. Now, with regards to a plea, there are negotiated pleas and there are open pleas. And with a negotiated plea, just as the name implies, you know what you've negotiated for. And in 99% of cases, the judge, provided the plea does not violate any laws, will accept that plea, provided the person actually goes through the process properly and can answer the judge's questions. And that is a process known as a colloquy, where a judge will ask you what you actually did, and you have to admit that you knew that that was a crime, and that's what you're pleading guilty to. With regards to an open plea, those are a lot more involved because you don't know what type of sentence you're going to receive, but your attorney should have told you a lot of information about the judge, the sentencing guidelines, and what you could expect to receive. Now, the attorney obviously doesn't have a crystal ball, won't know in most situations what exactly you'll receive, but he or she should have a good understanding of the judge's sentencing philosophy, your sentencing guidelines, your prior criminal history, and all of these things go into an open plea. Also, if it's a victim type crime like an aggravated assault or where a person was seriously injured, like an aggravated assault or a robbery or something like that, you have to understand that in most situations, the victim will have an opportunity to address the court, and that may really inflame the judge and may lead to an aggravated sentence. Now, you and your defense lawyer will have an opportunity to put on mitigation evidence, but again, you have to consider how strong that aggravating testimony is going to be. And I've heard over the years some pretty aggravating victim testimony, and you have to prepare your client for that, and you have to tell your client you're going to hear this person really kind of go off on you and really tell the court exactly what they think of you and how this incident has impacted their family and their quality of life. And that can be very impactful on a judge. I know if I was a sentencing judge and I heard something like that, I would definitely think twice about a sentence and possibly handing down a more serious sentence, because I want to give it a fair sentence, but at the same time, I want to show this person that what they did really caused an incredible impact on this victim and also society, because again, word spreads about a person receiving a light sentence for something very serious, and it may embolden others to consider that activity. So again, that is the point of sentencing. While sentencing, it's meant to rehabilitate someone and also punish. It is also meant to deter future conduct and to show society that we've taken this very seriously and the person has been appropriately punished for what they did. But if you have questions, 215 755-9000 in Pennsylvania, 856-793-7429 in New Jersey, 24 hours a day, 7 days a week. The website, GamboneLaw.com. As always, a tremendous resource for you and your family. All of my books, my blogs, my videos are available there in one convenient format. In addition, we have our podcast. This past Friday, like all Fridays, we had our weekly e-update, which went out to over 4,000 of our current and former clients in Pennsylvania and New Jersey. And I believe this question came in from someone who had received our e-update via email. We also share it on social media, and everywhere that our law firm is, you will probably see a copy of our e-update, whether it's shared socially or you receive the copy in your mailbox or your inbox if you're receiving it via email. Once again, if you have questions, 215-755-9000 in Pennsylvania, 856-793-7429 in New Jersey, 24 hours a day, 7 days a week. Have a great Sunday, and I'll talk to you all very soon.